I am Bishan Ramdani, that's me on the screen, Secretary of the Mauritius Bar Association, and I'm truly delighted to be your host for today. At the Bar Council, we're thrilled to see that our members have responded with the same enthusiasm and commitment we witnessed last year. I extend my heartfelt gratitude to each one of you for your unwavering trust in the association and its dedication to enhance capacity building. This year's conference theme, Rethinking Society and the Legal Profession, is not merely a catchphrase. It is a profound call to action. Let me emphasize that law is not practiced in isolation, nor does it exist in a vacuum. We as legal professionals are not just interpreters of the law, but agents of change and catalysts for societal betterment. Not a single day goes by without the law making headlines. From the authenticity of the moustache leaks to the responsibility of parties in a tragic Travelator accident. Today we gather to challenge our perspectives, to reimagine our roles, and to collectively shape a more just and responsive legal landscape. Ladies and gentlemen, for the opening ceremony, I'm honored to invite Nankishore Ramban SC, Chairperson of the Association, to deliver his formal address. Mr. Ramban, the floor is yours.
Thank you, Bishop. Honorable judges, ladies and gentlemen, esteemed colleagues and distinguished guests. It is an honor to welcome you all to this year's Mauritius Bar Association Conference. Change, as we know, is a constant force, sometimes gradual, sometimes sudden, that shapes our profession. As barristers, we must both adapt organically and engage in critical reflection to ensure that our legal framework addresses the evolving challenges of modern life. This year's theme, Rethinking Society and the Legal Profession, invites us to pose and consider whether our foundational principles and tools remain fit for the purpose in a rapidly transforming society. Over the course of this conference, we will delve into critical issues: a re-examination of our Constitution, the supreme law of the land, to assess its capacity to protect Mauritian citizens effectively. A discussion on the ethical dimensions of social media in legal practice, balancing modern connectivity with professional decorum. And an exploration of the dynamic interactions between barristers and the institutions we engage with, namely our judiciary, law enforcement agencies, international organizations, and the justice system's users. Our legal profession is younger and more diverse than ever, yet rooted in traditions shaped by those who have dedicated decades to its evolution. We are privileged to celebrate our confrères who have completed 50 years at the bar, living testaments to the transformation of legal practice and the enduring spirit of our profession. This conference also offers us the opportunity to hear from Mr. Douglas Kruger, a distinguished speaker on challenging self-imposed boundaries to foster productivity, innovation, and personal growth, qualities essential in today's legal landscape. I urge each of you to use this conference as a springboard to engage meaningfully, to embrace innovative thinking, and to spark the necessary conversations that may lead to real legislative and societal change. Let us remain steadfast in upholding our code of ethics while embodying the transformative agents that society expects us to be. This conference would not have been possible without the generous support of our sponsors, namely BLC Robert and Associates, Mr. Ravin Chetty SC, Mr. Subhash Lala SC, Mauritius Telecom Limited, Blue Fire Limited, Diamond Foods Company Limited, Eagle Onco Care Center, Karen Jijuwanji and Company Limited, Madame Gajador Chambers LLP, Mr. Patrice de Villepéville, Senior Counsel, Gamma Corporate Services, Mr. Abdul Razak Mohamed Pirou, Wensum Limited, Mr. Ramesh Kalatan DOSK, Absa Bank, Benoit Chambers, Assas International Limited, Lille & Co, Bamiris, Sea Resorts Hotel, Max City Property Fund. And we have also been sponsored in kind by Mauritius Telecom for the rapid internet you will be able to access today. The IGLS, who is our partner in this conference, BU for all the personalized associations with water, and of course, for those who will be here for the cocktail and dinner, the police band. I wish to place on record our real thanks for their unwavering support, and I'll ask you for a round of applause for those sponsors, because without them, this conference would not have been possible. So to that, we say thank you. I would fail in my duty if I would not place on record my sincere thanks and gratitude for the work performed by Kevina and Antish, the staff of the Mauritius Bar Association. Thank you, Kevina. Thank you, Antish. Last but not least, thank you to you all, my council members, for without your support, hard work, and more importantly, your patience with me, we would not have been able to put this together. Thank you very much, and at the same token, I thank you all to have made the effort to come and be with us today. So I wish you all a productive and inspiring conference. So let the fun begin.
Thank you, Chair. We shall now hear from Mrs. Davishka Sidrobiltu, Director of the IGLS.
Honorable judges of the Supreme Court, distinguished guests and members of the legal profession, ladies and gentlemen, all protocols observed, good morning. I warmly welcome you to the Bar Conference 2024, which is jointly organized by the Mauritius Bar Association and the Institute for Judicial and Legal Studies. I would, in the very first place, tender the apologies of the chairperson of the Institute, Honorable Mrs. Shamin Hamadlulu, for not being able to attend the opening ceremony of this morning, as she is taken up with her court commitments. The chairperson sincerely regrets her absence. The chairperson and myself are very appreciative that the IGLS is working hand in hand with the MDA in the elaboration of this conference. Today's conference is a testimony of the long-standing relationship which the IGLS maintains with the Council. The program for this year's conference is filled with exceptional speakers, focusing on diverse and interesting topics spanning rethinking society and the legal profession. The challenges facing law practitioners in the field of constitutional reforms, ethical behavior, and responsibilities of legal practitioners in relation to social media and publicity, and the role of the barrister within the workings of justice will be explored. In this vein, the value and role of continuous professional development cannot be overlooked. The IGLS has at its core mission training and fostering of legal education. In so doing, it is deeply committed towards the overall enhancement of the legal profession. CPD epitomizes a culture of lifelong learning, encouraging lawyers to challenge themselves intellectually in reaction to changes impacting the practical application of legal principles, and to stay relevant in their professional practice. This commitment not only benefits individual practitioners, but also enhances trust of stakeholders in legal services at large. Legal professionals should always be interested and concerned with developments in the legal field and its related disciplines, and this is why the IGLS deeply values forums like this conference. The legal profession is undergoing significant transformations driven by technological advancements, evolving societal expectations, and a shift in what constitutes success and ethical practice. Traditional rules, regulatory framework, and the nature of legal services need to adapt to these changes. The Constitution is the supreme law of Mauritius, and it is imperative for the profession to reflect upon those constitutional reforms which are fundamental to the upholding of our democracy. The key priorities of the recently held COP29 were as follows: securing a new goal on climate finance, ensuring every country has the means to take much stronger climate action, slashing greenhouse gas emissions, and building resilient communities. Countries like Argentina and Colombia have developed judicial processes that facilitate the enforcement of the right to a healthy environment. The incorporation of environmental rights into the Constitution is a transformative approach to establish a legal basis for challenging harmful practices. This in turn triggers legislative measures and fosters greater public engagement in environmental governance. In the context of the digital age, states have a multifaceted role that encompasses governance, regulation, and promotion of human rights. An inclusive, secure, and innovative digital environment is essential for states to effectively navigate the complexities of digital age while promoting societal well-being. On the other hand, social media is part of our life, be it in the private or professional sphere. Social media platforms offer significant opportunities for networking and client engagement. The intersection of social media and legal ethics have unlocked challenges for lawyers, requiring them to adopt the proper approach to harness the benefits of social media whilst upholding the integrity of their profession. The conference is therefore timely and important. The organizing committee's foresight in identifying these important themes is commendable, and the team has brilliantly put together a very enriching program which will give you an insight into many topical issues. The IGLS wishes to extend its deepest appreciation to all the high-caliber resource persons and moderators for the different panels. The MBA and the IGLS value their friendship with counterpart legal professional organizations overseas, and more particularly Réunion Island, our sister island. On this occasion, we are honored to have Mr. Mohamed Omoji and Mr. Eric Kudu as resource persons from Réunion Island. It is also our privilege to welcome amongst us for this occasion our keynote speaker, Mr. Douglas Kruger, who has traveled all the way from Jersey to be with us for this conference. Mr. Kruger is an eminent speaker on themes of leadership, productivity, and wealth. His books have gained popularity among professionals seeking to enhance their expertise and industry positioning. His works are designed to empower individuals to take charge of their careers and establish themselves as authorities in their fields. Thank you, Mr. Kruger, for gracing us with your presence, and we're really looking forward to your presentation. Dear attendees, we are sure that this conference will trigger lively discussions and that it is going to give you a platform to exchange ideas, reacquaint with colleagues, and broaden your knowledge. These exchanges will help to inform and enhance your work on international, cross-border, and universal legal issues. Rethinking society and the legal profession should be seen as a promise, not as a threat in any circumstances. Even if we might not be looking eye to eye, we are all looking in the same direction, the common imperative for all that justice and the rule of law should prevail. We wish the conference every success and wish you a profitable and enriching day. Thank you for your attention.
Thank you, Mrs. Sidro-Biltou. Remind members who have not done so yet that they must register in the entrance hall to benefit from 6 CPD points, including 2 for ethics. And do not be fooled by Mrs. Biltou's smile. Many of you will know by now that she will not hesitate to take action against mischievous law practitioners. So do register before you attend the conference. So today promises to be a unique and transformative day. We have curated 3 thought-provoking panel discussions, an exceptional keynote speaker who will challenge our thinking and inspire our professional growth. As we progress through the day, we will not just reflect on our past achievements, but also celebrate our future. We will honor our members who have dedicated an incredible 50 years at the bar, and also welcome our new Attorney General, Gavin Glover, SC, a testament to a profession's continuous renewal and dynamism. Speaking of the Attorney General, there has been a slight reshuffling in the program due to the swearing-in ceremony, which will be attended by some of our panelists this afternoon. It means that the 3rd panel will be after lunch, while our keynote speaker will address the audience in the final segment. The gala dinner will be preceded by a sundowner cocktail. And yes, for those wondering and who were left disappointed last year, we have a DJ waiting to help us unwind after dinner. We're prepared to demonstrate the same passion and precision you bring to the courtroom on the dance floor. A few housekeeping notes. There is an open Wi-Fi network that you can connect to throughout the day. Please ensure that your devices are on silent, and if you need to take a call, kindly step out to avoid disrupting proceedings. We'll be showing you a short video of our sponsors, to whom we are very grateful once again, and without whom this event would not have been possible.
Good morning and welcome to the first panel, which will concern concessional reform, as you know. I'm thrilled to be your moderator this morning on what promises to be a thought-provoking hour and a half. So my job as a moderator this morning is to facilitate the panel discussions between the 4 gentlemen here. It will be conversational style, so there will be no displays or PowerPoint, and we'll just be asking them questions and have their thoughts on the matter. These 4 panelists have been selected because they represent a different perspective, which hopefully will resonate with most of you. I will not do a very long introduction of our panelists, because for the most part, they need little to no introduction. But anyhow, you all have in your possession, hopefully, a copy of the conference magazine, which gives you their bio and self-description, and so we'll not eat up any more time. Suffice to say that it was essential for us to have the DPP here because the conversation is going to center also about his constitutional position. But the golden rule will be that we will not address any matters which are presently before our courts, and we will not delve into political discourse. So hopefully at the end of this session, we will wrap up with a Q&A session where some of you will have an opportunity to perhaps pick the brains of the panelists, ask questions, or maybe make any observations. And because the topic of constitutional reform is extremely vast, we had to be selective in the topics on which we want to shed light. And so this panel discussion will be structured in 3 parts. The first part is going to relate to the need for constitutional reform to better withstand potential threats to democracy. Under that sub-theme, we will address Section 72 of the Constitution. The second sub-theme that we will address relates to interrogations on how to strengthen or stretch fundamental rights as per Section 3, 5, and 9 of the Constitution. And lastly, we will talk a little bit and share our thoughts on what I like to call innovation. So novel rights which have emerged in the constitutions of many countries around the world. For instance, those that embrace economic, social, and cultural rights, or those that relate to environmental protection. Sur ce, nous allons commencer. Et ma première question, I will actually address it to the DPP here. And so far as you have recently highlighted the need for fundamental legal reforms to strengthen the independence, safeguard the security of the DPP offices, improve existing structures to make it an even more modern prosecuting authority. So, Mr. the DPP, do you feel that Section 72 should be revamped and modernized? And is it not sufficiently comprehensive as it stands?
Thank you, Caroline, and good morning to everybody. I think that personally there have been many events these last 2 years which should in fact provoke some kind of thoughts as to whether there's a need for review to bring constitutional amendments to our law. First of all, since we are talking about the Constitution, I just want to mention something. As we all know, the purpose of a Constitution is to provide for fundamental rights, separation of powers, to provide a system of check and balances, and so on and so forth. But whatever, you may have the best constitutional framework in a country, that in itself, it will not work. It doesn't guarantee that whatever is provided in that instrument, so important, given by the state to its people, is going to work unless there are certain factors which are satisfied. For example, it would depend whether the state itself provides for sufficient mechanism in order to give effect to these constitutional provisions. It would depend on whether the people who are given power, whether or not they use their power in accordance with the Constitution. It would depend also, in my view, as to whether there is any kind of internal or external influence which would affect the constitutional holder to be affected by the decision. Now, to answer your question whether Section 72, which provides for the post of the director and create the office of the director, whether it should be reviewed or not, I think I should say very briefly about the constitutional post of the director. As many of you would be aware, it was created in 1964 following some reports made by the Constitutional Commissioner, Professor D. Smith. What is important, the idea of creating an office of the DPP is to separate it from the executive, the political executive. This function was, in fact, was the role of the Attorney General, but subsequently it was decided that there should be 2 separate officers. And the idea behind it was to create to create the concept of the independent prosecutor, who was given security of tenure, who was given who had to hold the same qualification as a judge, so that he would operate independently, he would be able to take his decision independently, and he would play a very important role in the criminal justice system of the Republic. So that's the idea of creating the post of the DPP in 1964 and 1968. And Section 72, I would say, has stood with time. I think what a director needs in order for him to actually discharge his functions is provided in the Section 72. That is, there is that independence which is given, that he should not be affected by any external or internal factor. He must take his decision in accordance with the Constitution. He must act independently in the criminal justice system. There are powers, very specific powers, which are given to the Director of Public Prosecution, which he should exercise. But I would add that with time, with events which have occurred in society, in any society there are changes, and we must consider, we must give some thought about whether, and I issued a statement 2 weeks back, to say that it's time to look at the Constitution, Section 72, and there's a need to either strengthen the Section 72. Now, let me explain in what way. If you look at Section 72, I believe that the Constitution provides for an apex prosecuting authority or national prosecuting authority, which is the office of the DPP. However, there are other factors, there are other institutions which coexist and which are given some powers. For example, the police. We talk about law enforcement agencies. The police under the Police Act have the power to prosecute without coming to the DPP for consent. You have a recent law which was enacted, the FCC Act. The director is no longer here, but the law is still in our statute book, which doesn't require the consent of the DPP, as it is the case for other prosecution, to initiate prosecution. So, in my humble view, there is a need to look at this aspect of the law and to ensure, without any ambiguity, with certainty, that the National Prosecuting Authority is the office of the DPP, and I believe that the office enjoys a very good reputation with time. Since the creation of the post in 1964, I believe that all my predecessors, ils ont porté les flambeaux très haut, l'indépendance du DPP. Donc, therefore, there's a need to strengthen that office by giving appropriate powers to make it clear that the National Prosecuting Authority is the DPP. We know that there are pronouncements which have been made that powers of prosecution are delegated, all prosecution under the subject and control of the DPP. These are some Supreme Court judgments. We need to make that clear in the law. Most importantly, I think where we need to have review of Section 72, we need to give the director more powers in terms of ordering the law enforcement agencies to investigate criminal cases. Very often, we come across cases we heard in the public, within the public domain. There are cases that are reported. We don't know simply whether cases are being investigated, what is the status of the investigation, what's on. So it's time, I believe, and that is, in my view, in line with the prosecuting mandate of the DPP, that the DPP should be given express powers under the Constitution to direct the law enforcement authority to actually investigate a particular case. The second important point is that the DPP should also be able to provide guidance. This is where the principle of prosecution-led investigation becomes important. And if I may, I will very briefly refer to an article which I think some of you are aware. One of the former DPP wrote, it could be in the 1970s, that was Mr. Cyril Darifat, QC. And in this very interesting article, he asked the question, after he spent 10 years as DPP, he says, quel est le rôle, quels sont les pouvoirs du DPP en matière d'enquête? Deux solutions extrêmes viennent tout de suite à l'esprit. Selon la première, l'enquête n'est pas du ressort du DPP. Ni lui, ni son bureau ne sont équipés à cette fin d'enquête. Et l'enquête est l'œuvre du policier et donc éliminée sous la responsabilité. I agree with that. But he went on to say, selon la seconde, la poursuite ne peut que suivre l'enquête. Et l'on conclut que les DPP est par nécessité super contrôleur judiciaire de l'enquête. I agree with that. And then he said, à la vérité, ces deux positions ne sont pas contradictoires. Il faut distinguer entre les processus administratifs de l'enquête et les contrôles judiciaires de cette dernière. Les DPP, me semble-t-il, n'a rien à voir avec les premiers aspects, et quand au second, il jouit des pouvoirs limités. And this is where my suggestion becomes very important. That the DPP and Section 72 of the Constitution have very limited power insofar as providing guidance, insofar as to have a prosecution-led investigation. And you may ask, well, what is the business of the DPP when it comes to investigation? Many of you would think that the DPP should first address his mind when a file comes on his table after the investigation is over. Well, I beg to disagree on this. The modern trend is that the DPP should get in. Now, you should not confuse that with the idea that the DPP goes on the field and he investigates. No, the DPP, no, his officers are entitled to carry investigation. Nothing prevents the DPP from having a say insofar as the during the investigation. And one of the most important reasons is because at the end of the day, it's the director and his officers who decide whether to prosecute the case or not, whether there is sufficiency of evidence. So we cannot, in 2024, not be involved at all at this stage of investigation, not having any say, but at the end of the day, asked to take a decision and to initiate prosecution. And in that article, time is limited. After what I quoted to you, Mr. Darifat explained clearly the reason why the DPP should act, in fact, as le contrôle judiciaire, as a super contrôleur judiciaire de l'enquête, because of practical difficulties when it comes to advising a file, prosecuting a case, which at the end of the day, a very important piece of evidence no longer exists, or you have to ask for further investigation. That takes much time, and it's a waste of resources. So I believe, to answer your question, I think that it is important to review that Section 72 to the extent that the DPP should be, without any ambiguity, should be considered as the national prosecuting authority in Mauritius. I believe it is already the case. But to clear any ambiguity, we should make this very clear. Secondly, this power to actually provide guidance to order investigation where required, and very importantly, to supervise the legality of investigation. Very often investigations are carried out behind the back of the DPP, and there are many abuses which are made by law enforcement authorities, and these came out only when the case goes to court. Whereas the advantage of the DPP getting involved at this stage, it will ensure, in accordance with the Constitution, that the investigations are carried according to law, and that it is something which is lawful, so that at the end of the day, when the case is presented in court, we are almost certain that we have adhered to all important parameters. So to my mind, these are the important issues which we need to think and we should bring in terms of reviewing Section 72 of the Constitution.
Thank you for this, and I'd like to pick up on one of the things that you mentioned earlier and ask a question to Eric. And as gracious host, I will ask the question in French. Well, if you can answer in English if you wish, but I'll ask the question in French. Mr. the DPP, you spoke about prosecution-led investigations, but I want to make a parallel here pour te demander, Eric, de nous parler brièvement du rôle du procureur en France. Et dans quelle mesure on peut faire peut-être un parallèle et voir s'il y a des avantages à ce système existant en France qu'on pourrait peut-être émuler si on est dans une réflexion d'étendre les pouvoirs du DPP, si on est dans une réflexion de remodeler un peu comment les choses se font. Qu'est-ce qu'on peut emprunter de chez vous?
Merci Caroline. Si tu me laisses le choix, je vais parler en français. Il faut bien comprendre qu'en France, la procédure judiciaire, elle a trois phases. Il y a l'enquête de police, ce qu'on appelle l'enquête préliminaire, qui éventuellement se poursuit par une enquête menée par un juge d'instruction, qui est l'instruction, qui éventuellement va aboutir à un renvoi, si le juge d'instruction estime qu'il y a suffisamment d'éléments, à un renvoi devant une formation de jugement avec un autre juge qui est nécessairement différent et qui lui aussi va commencer son audience en interrogeant lui-même les parties. Donc vous avez l'enquête de police, l'instruction qui est menée par un juge et une seconde petite instruction lors du jugement qui est menée par un autre juge. Le rôle du procureur, à mon sens, il est important pendant l'enquête de police parce que c'est le seul moment où il n'y a pas de magistrat. Une enquête, c'est nécessairement attentatoire aux libertés fondamentales. On porte atteinte à la liberté quand on met quelqu'un en garde à vue, quand on l'oblige à venir au commissariat pour être interrogé. On porte atteinte à son intégrité physique quand on lui impose des prélèvements ADN, des prélèvements d'empreintes digitales. Par définition, on porte atteinte à sa vie privée et éventuellement, on porte atteinte aussi à son domicile avec des perquisitions. Notre conception, c'est que ces atteintes, elles doivent être contrôlées par un magistrat. Et c'est là que le procureur intervient. Puisque en France, l'enquête de police, soit elle est décidée par le procureur, soit le procureur est nécessairement informé dans un maximum de 6 mois et il peut y mettre fin. C'est pour ça que quand j'entends monsieur le procureur général nous dire qu'il y a des enquêtes qui sont menées in the back of the DPP et qu'il ne la prend que qu'arriver en cours, ça n'est pas possible. Parce que comme je vous l'ai dit, même si ce n'est pas lui qui est à l'origine, souvent c'est lui qui décide et qui donne un délai à la police pour faire l'enquête, il est obligatoirement informé et il peut y mettre fin. Et puis une fois que l'enquête a débuté, c'est pareil, on nous dit qu'on ne sait pas qui sont les enquêteurs. Dans l'enquête française, il y a un dialogue permanent entre l'enquêteur et le parquet. Donc vous avez tout ce qui est attentatoire à la liberté, finalement, doit être autorisé par le procureur. Si l'enquêteur décide de placer quelqu'un en garde à vue, et que ça n'a pas déjà été décidé par le procureur, il doit l'en informer. Le procureur peut mettre fin à la garde à vue. Si l'enquêteur, au bout de 24 heures, estime qu'il lui faut un deuxième délai de 24 heures, il doit obtenir l'autorisation du procureur. Si l'enquêteur, le policier, convoque quelqu'un au commissariat et que la personne ne vient pas, il doit obtenir l'autorisation du procureur pour arrêter la personne et la faire venir au commissariat pour l'interroger. Pareil pour les empreintes digitales, pareil pour les prélèvements ADN. Le procureur, finalement, il intervient à chaque fois qu'on va porter atteinte aux libertés de l'individu. Et vous avez enfin les perquisitions, où là, ce n'est même plus le procureur, c'est le juge des libertés qui intervient. Après, une fois que l'enquête de police est terminée, c'est le procureur qui décide s'il y a suffisamment d'éléments pour continuer. Donc, il va donner instruction au policier de convoquer la personne à une audience pour un jugement, ou alors il va saisir le juge d'instruction. Une fois qu'il a saisi le juge d'instruction, son rôle devient beaucoup plus limité, puisque là, c'est le juge d'instruction qui prend la suite. et c'est lui qui décide, qui l'interroge, quels actes il va faire. Le procureur, là, n'a plus que la possibilité soit de demander des actes ou de faire appel des décisions si elles ne sont pas conformes à ce qu'il souhaitait.
Très bien, merci. Vinod, I would like to ask your perspective on what you've heard from both Eric and the DPP. As an ex-judge and counsel of the state, do you share these views? Do you think there's anything that needs to be supplemented to that in our thinking as to how far to push Section 72?
Thank you. Good morning, everybody. I thank the chairperson of the Bar Council for inviting me here. Special thanks to Caroline for imposing that ordeal on me. The question, Caroline, was how to reinforce the powers of the DPP under Section 72. So far what we have heard is how to give powers to the DPP to direct the police investigation. This is something new. But what we must concentrate on right now is what the law says and how are there any loophole in the law that allows any government to interfere in the power of the DPP by giving not parallel power but removing the power of prosecution from the DPP, and how this can be remedied. If we look at this section that gives power to the DPP to initiate prosecution, this section says the DPP shall have power to initiate prosecution. Full stop. But when you look at the power of the DPP to put a stop to a prosecution, the section is very clear that power shall belong to the DPP exclusively. That word exclusive doesn't exist in the section that gives power to the DPP. And I believe this is a loophole that has enabled or that has been used as a platform to give exclusive powers to the director of the FCC to prosecute offences relating to financial crimes. This is the first point that should be amended in the Constitution. Because to my mind, this is a big loophole, and people can play on this. I know that many people have quoted the case of Benjamin decided by the Judicial Committee of the Privy Council, what the Privy Council said. I think it was from Trinidad and Tobago, I believe, I'm not quite sure, that the DPP doesn't have exclusive power of prosecution, and that the Commissioner of Police doesn't have to come to the DPP. But what the Judicial Council decided, the Privy Council never decided to remove complete prosecution powers of the DPP in Trinidad. But the Privy Council seems to be saying that the powers should exist in parallel to. Whereas in Mauritius, what the FCC has done is to remove all powers of prosecution in respect of certain offences from the DPP. And I believe it's because of what we hold in the section creating the power. This is the first thing that we should do. Secondly, the DPP has mentioned that when the police file comes on the table, he asks for further inquiry. I have worked in the police for 15 years, and whenever we ask for further inquiries, former police commissioners, if they had any doubt, they would not sleep on that request of the DPP. They would respect that request of the DPP. But they would come to our office to discuss on what line it should go. The DPP has said there should be a prosecution-led investigation at his office. Possibly the time has come for that, because usually in the previous days there was a tacit understanding between the police and the office of the DPP, where there was a constant dialogue. I have had, in my days there, the police commissioner come to my office and say, what have you done there? What is this? Okay? But we discussed within the four walls. There would be no criticisms, no discussions in public where one institution will be belittling another institution, as we have seen this, unfortunately. Okay? So how should we go about that police-led prosecution? I believe there should be a clause in Section 72 that gives power to the DPP to direct an investigation so that the police know exactly where they are going. If we don't have this in the Constitution, the Commissioner of Police will use Section 71 to say, I'm independent, I don't have to answer to the DPP. And it does not make sense that a police file, as the DPP has mentioned, comes on his table at the end of an investigation conducted by the police alone, and if that investigation is badly conducted, the Secretary in fact mentioned that in his article, if you have a dishonest police officer, or if you have a police officer who has his own interest to serve in an investigation, and he sends a file to the office of the DPP with a badly conducted investigation, and the DPP requests for further inquiry, and the police sleep on that file, what can the DPP do? Nothing.
Thank you for this, Mr. Boulel. I believe Mr. DPP wanted to actually respond to something that you just said.
I just want to add very briefly that is, under the current state of the law, the DPP is not the sole authority to prosecute cases. So this is what we should review. And the right of exclusive initiation and supervision of prosecution. I think that the DPP's office should, in fact, very expressly be provided with that power. But there is something which is very important, which maybe we can
ask one question. Where does it say in our law and in our constitution that other authorities have the power to prosecute? What does it say? How does it happen? Unless I'm wrong.
Yeah, I mean the system. I mean our statutory framework as it is. There is this section which, in my view, the office of the DPP is not the sole authority. And then what we have done, we have provided under the DCA or the Courts Act specific powers to the DPP. You cannot initiate prosecution without getting the consent of the DPP. So that is a kind of safeguard which is provided. But there's something which is important insofar as the right to private prosecution. This is something which is also something which must be considered, because by many it is considered as a very important fundamental right. If the DPP is the only national prosecuting authority, he doesn't want to prosecute a case, why should the citizen who feel aggrieved should not bring a private prosecution? So in my view, there are arguments for and against, but we can keep the right to private prosecution. But that, I'm speaking in terms of authorities, organizations. The sole authority should be the DPP, of course leaving it to the citizen, if they so wish. If the DPP is not interested in bringing a prosecution, they might do so. And of course the DPP would have the power to either discontinue or take over prosecution.
Thank you. I'd like to move on to the second part of this panel discussion, or to go to the very heart of our constitution, namely relating to fundamental rights. And my question will be directed to my confrère Antoine, specifically on Section 9 of the Constitution, insofar as the paper that was produced by the Law Reform Commission of Mauritius some 14 years ago now. That paper related specifically to constitutional protection of human rights. And it did say that the right to privacy under Section 9 of the Constitution was limited, and that its ambit had to be expanded to include not just privacy of home and premises, but also the respect for private and family life. I'd like to hear your views on this.
Thank you, Caroline. I have examined this point, and it is a fact that a combined reading of both sections, Section 3C, read together with Section 9(1), leads to the conclusion that the only right of privacy which is defined, which is recognized and safeguarded in our Constitution, is only to the extent that it affords protection for the privacy of your home and other property. That is to be found in section 3C, which is the preambular section, but which is nevertheless an enacting section. And then we move on to section 9.1, which lays down the rule, and the rule is very clear: except with your own consent, no person shall be subjected to the search of his person or his property, or entry by others on his premises. So that what is being safeguarded is search of your person or your property, or entry on your premises. And any exception to that general rule would have to pass 3 tests, which are laid down by section 9 of section 2. First of all, any exception must be provided by law, that is an act of parliament. Secondly, the second safeguard is that the exception must come within one or more of the constitutional exceptions which are limitatively laid down under section 9 subsection 2. And the third safeguard, which is an important safeguard, it must be reasonably justifiable in a democratic society. So that affords the possibility to the citizen, to the individual, to challenge any exception which may have been laid down by law. Parliament may very well enact exceptions, but then these are reviewable by the court to the extent that it must be shown that the exception is reasonably justifiable in a democratic society. Now, if you look at the more recent pronouncements and the best practices internationally, you will see that now the focus of attention is no longer on what is reasonably justifiable, but what is necessary. They no longer speak about what is reasonably justifiable, what is necessary in a democratic society. Therefore, brings into play the test of necessity. You have to establish before the court and to the court's satisfaction that these exceptions to the rule, the intrusion upon privacy, are necessary in a democratic society. Now, our constitution, as you well know, is a schedule to the Mauritius Independence Order of 1968. And bearing that in mind, we have to compare section 3C and section 9 with what preceded it, because we all know that all of these fundamental rights have been inspired or borrowed from the ECHR, the European Convention on Human Rights. And let us therefore consider section 8, article 8 of the ECHR, which protects the right to respect for private and family life. That is, the language is much wider. Article 8 of the European Convention on Human Rights, established by the Council of Europe in 1950, ours in 1968, and which is applicable across the European continent, safeguards the right to privacy. And it asserts that, quote, everyone has the right to respect for his private and family life, his home and his correspondence. Now, through extensive case law from the European Court of Human Rights, privacy has been clearly defined and universally recognized as a fundamental right. I now move on to Article 17 of the International Covenant on Civil and Political Rights of the United Nations in 1966, 2 years before our independence, which also protects privacy, quote, no one shall be subjected to arbitrary or unlawful interference with his privacy, family, home or correspondence, nor to unlawful attacks on his honor and reputation. Everyone has a right to the protection of the law against such interference or attacks. Now, the state of Mauritius is a party to that convention, and that is therefore a right which may be invoked by a litigant in Mauritius. Now, on account, presumably, I suppose so, I presume that it is so, presumably on account of the lacuna in sections 3C and 9 of the Constitution, Parliament passed a law in 1981, Act number 25 of 1981, and enacted the chapitre 3e, which was embodied in the Code civil Mauritian, which is du respect de la vie privée, and contains an Article 22, which lays down the right as being as follows: chacun a droit au respect de sa vie privée. And in order to enforce that right, there are two further provisions, two other alineas. The second one, les juridictions compétentes, meaning that all the courts of competent jurisdiction peuvent, sans préjudice de la réparation du dommage subi, prescrire toute mesure telle que séquestre, saisie et autres propres à empêcher ou faire cesser une atteinte à l'intimité de la vie privée. And the third and last alinea, even provides that ces mesures peuvent, s'il y a urgence, être ordonnées par le juge en chambre. Therefore, we may apply to a juge de référé for in cases of urgency. But all the courts of competent jurisdiction may, instead of avoiding damages, waiting for the damage to occur, they may take preemptive action in order to prevent the wrong from being done. And the footnote to that article reads as follows: cet article reprend in extenso les termes de l'article 9 du Code civil français, loi du 17 juillet 1966. That is 2 years after our independence. We have enacted it in 1981. Il s'imposait étant donné que les atteintes à la vie privée sont aujourd'hui plus fréquentes en raison du développement des moyens indiscrets dont disposent notamment les médias. So we have to move with the times, and I will conclude by referring you to what was observed by Professor Jeffrey Robertson QC in his preliminary report of 2013, Media Law and Ethics in Mauritius, where he observes that there is no clear protection for individual privacy in Mauritius. And he goes on to say there have been few privacy cases in Mauritius, in Mauritian law. Although sections 3 and 9 of the Constitution give an individual the right to protection for the privacy of his home and property, this seems confined to protection against invasion of the home and may not cover invasion of the person. For example, by use of telephoto lenses or obtaining confidential medical data or information from private diaries. And he gives thought to Article 22 of the Civil Code, and he says that it does not provide a right to damages and permits access to judging chambers in urgent cases, but is unspecific about the remedies the judge may grant or the principles on which he or she may grant them. Although measures available will include seizures, injunctions, and interim orders. And then he comes to grips with the case which occurred in January 2013, when the media of Mauritius expressed great surprise when an interim injunction, which was granted by Mr. Justice Thomas, was discharged a few weeks later. In that particular case, interim injunction had been granted after an urgent application before the judging chambers. That was in the Sunak matter, and the application was based on the privacy provisions of Article 22. There was much criticism of the court, but as the judge made clear in his decision, published 5 days later, The injunction was, as a temporary measure, entirely justified, and the learned author says the following: I would pause here to recommend to the judiciary, with respect, that whenever they grant an order which imposes even brief restraint on the press, so this is a case of prior restraint, they should, in deference to the importance of free speech, give their reasons at the same time as they make the order. So the order was made, but the justification for the order came only 5 days thereafter, and as you well know, there was a subsequent decision of Mr. Justice Balanci, who decided to discharge the injunction for the reasons given by him in great detail in the subsequent judgment. Now, in order to conclude, I would also draw your attention to the fact that there is a tension between the right to privacy and freedom of speech. And this is what Professor Robertson has harped upon. And he says the following, which is, in my view, correct. I do not agree, incidentally, that privacy and free speech are of equal value. Free speech is fundamental to democracy and is a right that serves the entire community, whilst privacy is a claim made by an individual, often a powerful individual, to stop the truth from coming out. Free speech must override privacy, in my view, unless what is sought to be published contains intimate personal details of the individual or his or her home or family, and when there is no particular public benefit other than public curiosity to be derived from the publication. And he concludes as follows: this is broadly the test that I recommend should be adopted to replace Article 22, and is a test of the kind that has been approved by European jurisprudence. So that sums up the whole matter.
Thank you very much, Antoine. You've been mentioning a few cases, and I think, sorry about that. You've been mentioning a few cases, and I think, Mr. Boulel, you've done so as well. I want to direct one question to some of you, because obviously we're limited with time. Regarding the participation of Council in furthering this agenda of upgrading the Constitution. In many cases, the judgments have had the effect of clarifying what is understood by certain provisions of the Constitution. We've seen that, we've seen that in the latest constitutional judgments, where the Supreme Court sees the opportunity to further stretch the meaning of certain words relating to discrimination. So what are your views? I want to ask Mr. Boulel about this first, and then perhaps Eric from a comparative law perspective. Quel est le rôle participatif que l'avocat peut jouer?
Well, we have a constitution. However, what the ideas are, it's very difficult to have changes in the constitution because of the weighted majority needed in many cases. Now there is more than a weighted majority. Let's see what will happen. But when the legislator is unwilling or is unable to make any constitutional changes, I believe the legal profession, you, members of the legal profession, have an important role to play in getting the Supreme Court to amend the Constitution, amend between those it comes. Let's take the case of ASIC. If Gavin Glover did not have the temerity, along with his colleagues, and courage to go to the Supreme Court to have the law amended, so that people with specific sexual orientations could live their life freely, this law would have stayed in the statute book. It demanded the courage of a lawyer to have this law struck out, and in indirect way bring a constitutional change to the right of privacy of some people. So this is where the legal profession has an important role to play. In the same way, the legal profession has played an important role regarding elections. Several years ago, regulations were made to impose a deposit of 10,000 rupees for a candidate standing at an election, where the figure was 220 rupees. Mr. Guillaume, the late Guillaume, went to court to challenge this. He said, you cannot impose such an enormous amount on a candidate who wants to stand at election. But the right to stand at an election is provided in the Constitution. By imposing such a heavy burden on him, you are restricting his right. Okay? And Dala struck down this regulation saying it's enormous. And he even made a mathematical calculation. He said if a party is fielding 60 candidates, multiplied by 10,000, how many millions of rupees would be needed for candidates to stand at election? So these are two instances where the activism of lawyers have made a change in society. Thank you.
Thank you very much. Eric, est-ce que ce mot activisme, ça vous parle? Dans quelle mesure vous avez vous-même été témoin de cela? Est-ce que ça se pratique?
Oui. Avant de changer la Constitution, il faut déjà l'appliquer. La Constitution, ça ne doit pas être un objet sacré, une étoile au loin qui guide le législateur, mais que nous, on ne touche pas. Il ne faut pas hésiter à invoquer les droits fondamentaux dans nos propres dossiers. Je vous donne un exemple très, très concret. Il y a quelques années, un client est venu me voir parce qu'il n'arrivait pas à aboutir dans une action en reconnaissance de paternité. Il faut savoir qu'en France, le délai pour se faire reconnaître fils de quelqu'un ou fille de quelqu'un était de 30 ans, il est passé à 10 ans. Et donc, 18 plus 10, ça fait 28. Ce monsieur, il a agi sur un problème de succession après le décès de son père. Il n'avait pas été reconnu et on lui a dit c'est trop tard. Ce délai de 10 ans, il a été appliqué par la Cour d'appel, alors même qu'on savait pertinemment qu'il était bien le fils de la personne décédée, puisqu'il y avait déjà eu, pour différentes raisons, des tests ADN. Je suis monté à la Cour de cassation et on a dit à la Cour de cassation cette loi nationale qui refuse, pour une question de délai, à une personne d'être reconnue comme le fils de son père, elle est contraire à un droit fondamental qui est d'ailleurs dans la Convention européenne des droits de l'homme, qui est le droit à la vie privée et à la vie de famille. Et ça a déjà été appliqué d'ailleurs par la Cour européenne des droits de l'homme. Et la Cour de cassation a cassé l'arrêt en disant en refus, le juge d'appel n'a pas justifié en quoi cette violation du droit à la vie de famille était proportionnée au but poursuivi. Donc concrètement, il a cassé, la Cour d'appel a suivi, il a cassé la décision qui appliquait un délai de prescription prévu par la loi nationale. Il a refusé d'appliquer cette prescription parce qu'il considérait que ce délai, dans ce cas précis, portait atteinte à un droit fondamental qui était le droit à la vie de famille. Alors, vous avez des exemples toujours en droit des affaires, par exemple sur les baux commerciaux, où vous avez une décision qui a annulé la clause d'un contrat de bail commercial dans un centre commercial. Le centre commercial, en fait, imposait à ses locataires d'adhérer à une association de commerçants. Et cette clause du contrat a été annulée par la Cour parce qu'elle considérait que ça portait atteinte à la liberté fondamentale d'association. La liberté d'association fait partie en France du bloc de constitutionnalité depuis 1946. Au pénal, et j'en finirai par là puisqu'on est short of time, vous avez une infinité de décisions, mais je vais vous en donner une parce qu'elle concerne un avocat. Le jour du 31 décembre, le soir du 31 décembre, un avocat intervient en garde à vue pour un mineur. Le mineur lui se plaint d'avoir été victime de violences pendant la garde à vue. Et donc, en France, ce qui se passe, c'est que l'avocat il vient avec son papier, son stylo, et quand il y a des observations à faire, il les note, et il dit au policier de les mettre dans la procédure. Donc c'est ce que l'avocat fait. Il s'ensuit une dispute, et l'officier de police judiciaire décide de placer l'avocat lui-même en garde à vue. Il le place en garde à vue, et il lui impose un test d'alcoolémie et une fouille de corps intégral. Donc forcément, l'avocat porte plainte, il dépose 2 plaintes, une pour faux et usage de faux dans les actes de la procédure, et une pour séquestration. Malheureusement, le procureur, puis la cour d'appel, donc les magistrats français vont croire le policier plutôt que l'avocat, vont dire qu'il n'y a pas de raison de remettre en cause la parole du policier. Et donc l'avocat est allé jusqu'à la Cour européenne des droits de l'homme. Et c'est la Cour européenne des droits de l'homme qui a finalement donné raison à l'avocat sur le nouveau principe fondamental, qui est le fait qu'il ne peut pas y avoir d'atteinte arbitraire au droit à la liberté. L'avocat intervenait justement en tant que garant contre cet arbitraire. Il a été lui-même victime d'une telle atteinte et la France a été condamnée. Voilà.
Merci. Peut-être la perspective, Mr. Amin, perhaps you want to just say very quickly something about the position from the state.
Yes, I do agree with the other panelists that lawyers, in fact, play a very important role when it comes to fundamental rights. When the opportunity arises, you can mount a case in court, and you try to convince the court to give judgment in a duty to ensure that fundamental rights are respected. But that is not the only way to do it. Like, for example, very often there are issues which arise. Let us take, for example, civil liberty, right to personal liberty. A right to personal liberty is so important, but very often in Mauritius, unfortunately, I don't think that there's anything to change about the provision in the Constitution. It's strong enough, it protects a right to liberty of individual. In other jurisdictions, we have similar provisions like ours. Some of them, they have taken the pain to say that no one should be arbitrarily detained. That is one important right in the Constitution. But as I said at the beginning, it's not the provision in the law alone which matters. It will depend on many factors. In Mauritius, for example, why is it that right to personal liberty very often has been abused? Has been abused because law enforcement authorities, for example, they've not played their role in accordance with the Constitution. And when these things happen, lawyers have a very important role to play. When, for example, in Mauritius, the Commissioner of Police actually lodged cases against some people in presence of the DPP when I took some decisions, I must say, I'm not commenting on that case particularly, but I must say that I didn't hear anything, almost anything from members of the bar. Except, I think, I'm very happy that by my side, Vinod is here. He expressed himself in various articles which were published in the newspaper, giving his views about, these matters. Antoine, as well, I think, gave several interviews in his capacity as senior counsel to express his views about what's happening. But the Bar Council, I didn't hear anything about it. I must say, for the last few years, we do not have a strong criminal bar in Mauritius. Hardly do we hear lawyers voicing their concern when it comes to fundamental rights. As director, I was defending the Constitution. Now, I was not expecting lawyers to support my position, but in many developed jurisdictions, you would have lawyers who would come forward and ask permission from the court to act as interveners in order to enlighten the court, because these are very important provisions of our constitution. So to that extent, I noticed that in Mauritius, what I've seen, that is, we didn't have that much response in terms. It cannot be a question about between the DPP and the Commission of Police. It's about fundamental rights, and then very often you have lawyers who would write to me to say we would wish that the DPP intervened because there's police objection, or we would wish that some people are under arrest. And the Commission and the DPP is not a party. We wish the DPP to be put into cause in order to take a stand. So these are important rights which we need to defend. And when it comes to fundamental rights, I would just add that, as I said, our law is sufficient. It's a question about law enforcement agencies that must go according to the Constitution. Secondly, the court as well, I think, has a very important role to play. An example, what I heard during the electoral campaign, for example, somebody was arrested simply because I think he removed some banners at a particular roundabout in Mauritius. And that person, what I read in the newspaper, was detained for 5 days. So you have the Constitution which provides for fundamental right to freedom. You have somebody who is brought before a court of law, possibly he's not represented. What is the role of the court? If the police say, we wish to detain him, does the court act as a rubber stamp and detain that person? This is not, in my view, what the Constitution says. The Constitution says that the court must investigate what are the reasons you want to detain that person who allegedly has removed banners at the roundabout. What are the grounds on which you would wish to object for his detention? But can you imagine that person is stayed for 5 days in police cell and then subsequently was released? So we have fundamental rights in our Constitution on paper, but sometimes it can simply remain a dead letter. It would depend. And I think in that context, the PACE, the Police and Criminal Evidence Act, is so important, something which we have asked for since a long time back. And those who had the opportunity to look at the draft when it was prepared in 2016, you will see that would put a lot of, will gear towards more respect of human rights, and any kind of abuse of human rights would be monitored in a better way. Thank you.
Thank you very much, Mr. DPP. Anton, I think you want to say something, but we're very short for time because we want to move on to the next topic. So, just a few.
Je ne vais pas épiloguer trop longuement sur cette question, mais il est bon de rappeler que pendant le Covid, les avocats ont défendu l'honneur de la profession devant le full bench de la Cour suprême, qui a siégé remotely, c'est-à-dire par vidéolink, et nous avons porté devant la Cour la question de savoir si un suspect avait le droit d'être représenté par un avocat suite à une arrestation par la police, même pendant le Covid. Donc, ça c'est pour répondre à cette question concernant l'activisme du barreau. Moi, je conclurai en disant qu'il faut que le barreau mauricien soit foncièrement indépendant et qu'il démontre son indépendance vis-à-vis du pouvoir en place. Ça, c'est la condition sine qua non d'un independent bar, c'est-à-dire d'une institution qui veut être reconnue comme telle. Et la troisième chose que je souhaiterais mettre en avant, c'est qu'il y aurait beaucoup plus d'activisme si, au lieu de nous restreindre à défendre des intérêts purement privés, on nous permettait aussi, à travers le Public Interest Litigation et les Class Actions, de nous intéresser aussi, non plus aux intérêts purement privés, mais aussi à l'intérêt public. Et ça, c'est un autre thème que nous allons développer dans quelques instants.
Alors, c'est une parfaite transition parce que dans la troisième section de ce panel, j'aimerais qu'on évoque en fait ce sujet de public interest litigation. the class actions, because it's a topic that has been, it's been brooding in Mauritius for a while, and it's perceived as a means to secure constitutional rights, especially vis-à-vis minorities. And I know that this morning, this is one of the things that you actually wanted to bring up, so I'd like to invite you, Antoine, to tell us a little bit about this and what is your view, and to what extent this is actually linked to this topic of reforming the constitution and how furthering constitutional rights.
On this particular topic, let me recall that under the Roman law, there was already in place what was known as the actio popularis. The actio popularis was an action under the Roman penal law which was brought by a member of the public in the interest of public order. Similar, therefore, to a private prosecution, which flows directly from the actio popularis of the Roman penal law. Now, in our law, we have the important writ, which is the writ of habeas corpus. Any third party, having knowledge of the facts, may run to a judge and apply for a writ of habeas corpus. And the cause of detention or detainer will immediately be looked into. So that is another example, if we were to need one, where public interest litigation is already embodied in our legal structure. Now, you will no doubt be aware that public interest litigation has developed hugely in India, and not only in India, but the action also exists in some modern legal systems. I will take one very simple example. In Spain, an actio popularis was accepted by the celebrated judge Garzon in June 1996, which charged that certain Argentine military officers had committed crimes of genocide and terrorism. The actions were brought by the Free Union of Lawyers and the Madrid Argentine Association for Human Rights. Private citizens and organizations who were not themselves the victims of the crimes in the action and who proceeded without the sanction of the public prosecuting authorities. So that is another example of activism by lawyers. In India, public interest litigation has been used to guarantee several human rights, including the right to health, livelihood, free and compulsory primary education, unpolluted environment, shelter, clean drinking water, privacy, legal aid, speedy trial, and several rights of those who are awaiting trial for the rights of convicts and prisoners. It is also important that I should share with you the statistics. On average, the Indian Supreme Court receives each year over 25,000 public interest litigations. Each year, 25,000. And between 1985 and the year 2020, over 9 million PILs were filed in the Supreme Court of India. More than 9 million. Therefore, public interest litigation has a vital role in the Indian justice system, and it has achieved objectives which could hardly be achieved through conventional private litigation. It offers access to justice to disadvantaged sections of society, provides an avenue to enforce collective rights, and enables civil society to spread awareness about human rights. This is seen very frequently in the United States, where the NGOs are very active and fund public interest litigation. Public interest litigation also contributes to good governance by keeping the government accountable. And the Indian experience also shows that it is critical to ensure that it does not become a facade to fulfill private interests, settle political scores, or gain easy publicity. So that is an important matter to be borne in mind. And insofar as the judiciary is concerned, in a democracy, the judiciary should not use public interest litigation as a device to run the country on a day-to-day basis or enter the legitimate domain of the executive and the legislature. So these are the safeguards which must also be put in place. And therefore, to conclude, the challenge is to strike a balance in allowing legitimate public interest litigation cases and discouraging frivolous ones. One way to achieve this balance would be to confine it primarily to those cases where access to justice is undermined by some kind of disability. So I would conclude therefore on that note. Welcome questions from the floor.
Thank you. No, actually, we take I'll ask one last question because we are running out of time. I want to just touch on the subject of pushing the limits of the Constitution to encompass the recognition of the right to an environment that is not harmful to the health or the well-being. You broached that earlier, Antoine, as one of the public interest litigation that were brought in India, the right to free air or clean water. Why is that opposite in Mauritius?
Mauritius recently had a pronouncement. I should also refer to it. We had a pronouncement recently. The court has held that any member of the public may invoke those rights, because these are collective rights. These are not individual rights. Because normally you go and protect individual rights because of locus standi, pas d'intérêt, pas d'action. Here we are talking about collective rights, rights which belong to every one of us.
Vinod, perhaps you want to address us on this. I know this is a topic that is important to you.
These are three important matters. The economy and climate change. And I believe one completes the other. Because without taking any adequate measures on climate change, that may impact on the economy and the quality of life of the citizens. Now the question is how to enforce the protection of the citizens. Do we go to court and force the state to take appropriate measures regarding climate change? Or do we include in the Constitution clauses on climate change? Because if we include clauses on climate change in the Constitution, that might create a problem. Because climate change will evolve. And amending these sections will be difficult. Either you will need 2/3 or 3/4. Okay? But many countries have included these in their constitutions, especially countries in Southeast Asia. But in other countries, what litigants are doing, they are using the existing law on climate change and going to court to challenge the inactivity or arguing that the state is not doing enough to protect citizens from the harmful effects of climate change. The European Court of Human Rights has issued a number of judgments on this aspect, and to sum up, they have said that if the state is not doing enough to fight climate change, this impacts on life and privacy, because the quality of life can be damaged by the inadequacy of action on climate change and the inaction of the state.
Thank you.
Suppose is an example, but I don't know what is happening there. I don't want to comment too much on it. It can be either political or legal.
Thank you so much. So this wraps up the conversational part of our panel. Since we are short for time, we'll only be able to take a few questions. So if any one of you would like to ask a question or make a brief observation, this is not the opportunity to settle scores. So please, let's try to be brief. Thank you. Jacques.
Thank you. When you talk about public, the private, our constitutional rights, I, for my part, I have lost quite a few cases on constitutionality, but I lost all of them. But I would say judges are very conservative. They're scared to go to the unknown. But I'll just refer to two cases. When you remember, there was a pandemic, not like COVID, years ago, when the Chinese workers were prevented from coming to Mauritius. They couldn't take the plane from Shanghai or Macau or Singapore or Malaysia. So they went direct to Paris, and from Paris they came to Mauritius to be landed. Two cases were lodged in court on the day of the lodging, and both cases were thrown out. So my point is that it's easy to talk and say when you're in a room, when it comes to genuine life interest of people, life at that point in time, it's very difficult to adjudicate, and it's best to adjudicate in favor of the government. That's all.
Thank you very much, Jacques. Any other questions for one of our panelists or observations from the floor? Mrs. Gallagher.
It's not a question, je vais rebondir sur ce qui a été dit, and I'm talking on behalf of the lower judiciary. What I wanted to say is that as judicial officers, we are very active in interpreting or in giving the provisions of the Constitution the meaning that it should. So we do judicial activism, and the Constitution ensures the right to a fair trial. It ensures that individuals are protected and have constitutional rights. So whether it is the right to a fair trial or whether it is the right to liberty, we are very far from being only statutes adorning the bench. We intervene where we should. We have our own limitations, and we know our limits of intervention, but what we always do is to ensure that the rights are respected, people are granted bail. So this is how we are active in the operation of the constitutional rights, and it is our own way of creating judicial activism for constitutional provisions. Thank you.
Thank you so much for this. I think it's very interesting I would have loved to have a magistrate on this panel for you to share judicial activism as part of this elan relating to constitutional reform. Any other questions? I'm sure everyone is... we'll take a last question.
Thank you. My question would be regarding public interest litigation. Today it is foreign to our jurisdiction. If we go to open the door for public interest litigation, would it not open floodgates? I would suggest that we have a check and balances system, such as in judicial review cases, there's a lead stage, in order not to have frivolous application, which would block the court system.
Thank you.
My Indian example, because that has been the result of judicial activism in India. There has been a purposive interpretation of the Constitution, as a result of which you will have seen the numbers, because I gave you the statistics. From 1985 to 2020, no less than 9 million applications in India. these cases would never have seen the light of day if we were to go through a leave application. So in India, if you come across a situation where prisoners are being ill-treated, fundamental rights are not being observed, they are being trampled upon by the SST, for example, because people can't exercise the freedom of speech, the banners are being sort of taken away forcefully from them violently, they are being arrested. When there is a right to free speech in Mauritius, you have the right to criticize those who are in power, and these fundamental rights are being trampled upon. What do? You need to file an application by one of these persons, or is it possible for any member of the public to write to the court, even send a telegram? In India, a letter would suffice. And of course, the judges would look at it and they would say, out of 9 million cases, there are at least 1 million which are deserving of being looked at. I'm not saying that because there are 9 million cases which land on your desk that you should therefore deal with all of them. But out of the 9 million, there must be a considerable number, in my view, of meritorious cases which should be looked into. You can't close your eyes to the obvious, and public interest litigation has nothing to do with administrative law. It has to do with collective rights, what the public interest demands. And that concerns every one of us. And you are not defending, as a public interest litigant, you are not defending your own right. You are defending the right of those who cannot defend themselves. Just as the bar is bound by its own rule of ethics, and it is bound to undertake pro bono work. So when we speak about activism of the bar, we also speak about our fair share of pro bono work which has got to be undertaken by every one of us. So I am not in favor of prior restraints preventing someone from writing to the court, or the court going through a leave process. The leave process will be taken by the judiciary, and they will decide on a case-to-case basis which cases are frivolous and which cases are meritorious.
Thank you very much. I think that's all we have time for. I invite you all to give a big round of applause to our panelists.
Thank you very much, Caroline, and thank you to the panelists as well. Please stay where you are. We'll be taking a group photo of all of you.